which shows that Mr. Scott, observed the splash on the monitor and alerted the dive supervisor, Mr. Farah, that something went wrong. It was not part of his duty to be stationed at the monitor. Let me repeat that again. Mr. Scott, there's evidence before this commission that Mr. Scott was the one that observed the splash on the monitor, and he alerted Mr. Farah that something was wrong. Freestanding from that, Mr. Chairman, I ask you to consider that it was not his duty to be stationed at the monitor. In this regard, we ask the Commission to note the evidence of Mr. Archibald under cross-examination, which can be found at transcript dated 5th January 2023, page 280, lines 7 to 15. There you would find a series of questions, Mr. Chairman, which I put to Mr. Archibald, and he accepted that it was not Mr. Scott's function to be stationed by that monitor. Rolf Seals had nothing to do with the work at berth 6 on the day in question. He was called upon after the accident to lend support and had very limited involvement in this matter as outlined in his witness statement, which could be found at page 3130 of the supplemental witness statement bundle. That's all I would say on Mr. Rolf Seals. He effectively had nothing to do with the incident on the day in question. I now turn to Houston Madrad Singh. Houston Madrad Singh's involvement was as an employee of Paria, working under the direction and reporting to Mr. Terence Rampasad Singh, which Mr. Rampasad Singh himself confirmed. He came into focus because he was the applicant under the permit to work procedure on the said 25th February 2022. It is our respectful submission, Mr. Chairman, that this focus was unwarranted. The permit to work procedure was used in these proceedings repeatedly as if it embodied Houston Madrad Singh's obligations in connection with the works. We respectfully disagree that the permit to work procedure can be used in this manner. There was no evidence as to how the permit to work procedure was supposed to work when a contract for specific works was in existence, as was the case here. I ask you to consider that. There was no evidence that the permit to work procedure was a contractually binding document at all. That's our respectful submission. There was evidence, however, adduced under cross-examination from Mr. Mushtaq Mohammed and Mr. Randolph Archibald as to the status of the permit to work procedure. But no evidence was produced by the Commission of Inquiry itself. Mr. Mohammed stated under cross-examination that the obligations under the permit to work procedure were general guidelines only, and he stated this, so that different people with different roles would have an idea, or they would have guidelines around what their roles were in the execution of the works. This could be found at transcript dated 4 January, page 2023. 4 January 2023, page 254, lines 24 to page 255, line 2. Archibald stated under cross-examination that there are rules and responsibilities that must be followed. This was stated on the 5th February. It could be found in transcript page 258, line 27 to page 259, line 1. It is to be noted, however, that under cross-examination, Mr. Mohammed also stated that there is nothing the Commission could refer to determine what was the intention behind the permit to work procedure. That is in evidence, and it can be found on page 259, transcript dated 4 January 2023. We respectfully...
Sorry, just a moment. What do you say that it is then? What is the permit to work? What is its purpose?
Well, the permit to work procedure, respectfully, Mr. Chairman, sets out its purpose on the beginning of the document, which can be found on page 24 of the core bundle, it has what its purpose is. Our respectful submission is that there was no evidence to suggest that this was incorporated into the contract that existed between LMCS and Paria.
But how can you carry out the contract if you don't get a permit to work?
Can you repeat the question, please?
Yes. How can you carry out the contract if you do not obtain a permit to work?
How can you carry out the contract
Yes.
if you do not obtain the permit to work?
Yes, you need the permit to work in order to meet the terms of the contract.
Yes, but there's no provision in the contract, Mr. Chairman, which incorporates the permit to work procedure. I have looked at the contract.
So I can assure you.
Right.
My concern is that if you're seeking to separate completely the permit to work from the contract, I'm not clear what you're saying the status of the permit to work is.
Well, Mr. Chairman, respectfully, there are some questions that I am about to outline which we say must be answered. Right. Because this was a problem in these proceedings, what the status of the permit to work is in the face of a contract between the two parties. It is something that the Commission would have to consider.
I appreciate that you were at pains to make that point during some of the cross-examination. I'm slightly concerned about the approach that you've taken because you suggested, and it was rebuffed, that the permit to work procedure was a guideline. It is not a guideline. It is something that must be adhered to. It follows from that that you must obtain a permit to work. In order to carry out the contract that's been entered into between the parties, you have to obtain the permit to work. There's no other way of doing the work or meeting the contract without...
Does the contract say that?
Well, it is, if it's not explicit, it is certainly implicit.
Well, I mean, it's open for you to make that finding, Mr. Chairman, but our submission is that it was not incorporated into the contract.
No, well, formally maybe not, but how is it that you're to perform, if you do not obtain a permit to work, how do you perform the contract?
Well, you see, and that is one of the issues that we have with the permit to work. There was no evidence led before this commission which would basically inform us as to what was the status of the permit to work procedure having regard to the existence of a contract between the parties.
Right, separate for a moment the procedure from the actual permit to work. Right? There's the procedure to obtain the permit to work, and then there's and then you have the permit to work. Right?
Yes.
Now, do you accept that you must obtain a permit to work before the work can be carried out?
I do accept that.
Right. And in order to obtain that permit to work, you have to follow the procedure laid out by Paria.
It was the contractor's obligation to follow that procedure. I have not seen a specific provision.
I follow that it is the contractor's obligation to follow the procedure. The procedure is Paria's.
Yes.
Right. So Paria have the procedure to obtain a permit to work. Yes?
Yes.
None of that is effective unless you have a contract with them. I can't just go and apply for a permit to work over at Paria. You have to have a contract in the first instance, don't you?
Well, in this case, yes.
Right. Well, let's deal with this case. Right?
Yes.
If you have a contract to work between LMCS and Paria, the only way LMCS can meet that contract is to turn to Paria's procedure for the permit to work, observe that procedure, and then apply for the permit to work.
Yes, they were.
Then you get the permit to work, and then you can carry it out.
Yes, and they were obligated to do that under the contract.
Right. So I don't really understand what your point is.
With respect to what, Mr. Chairman?
Well, you're saying that there's nothing to show that the permit to work is part of the contract.
That is our respectful submission.
Yes.
I have not seen
how does that impact on the decisions that have to be made here? How does it help us determine the responsibilities and whether they were followed or not? LMCS's duty once they'd obtained this contract, was to go to Paria's permit to work procedure, observe it, and obtain the permit.
Yes.
Their case is, well, you might have obtained the permit, but the permit doesn't permit you to do what you did. That's their position.
Yes.
That is a position I readily understand.
Yes.
What I don't understand is the way in which you're putting it as though, what am I supposed to do with the permit to work then, in respect of your client?
Well, and what we are saying is that there is no evidence before this commission which would inform the commission how to treat with the permit to work procedure.
Right.
That is our respectful
There's no
submission.
evidence before us as to how to treat the permit to work procedure.
Yes, and it's apparent from the confusion by Paria's own witness. The general manager has a different interpretation as to the status of the permit to work procedure than the man who drafted the permit to work procedure himself.
Oh, no. That has not passed us by, that there is some confusion as to how it's to be applied. There's some confusion about who the applicant is, what his role is. That I entirely understand.
Yes.
And some focus has been played upon it.
Yes.
By many of the parties,
Yes.
Including ourselves. I don't see how that. What I don't understand and what I'm not following from you is how does it make the slightest bit of difference to make the assertion that you do that the permit to work is not part of the contract? How does that help you?
How does it?
Help you on behalf of your client?
Well,
If suppose I was to accept, all right, it's not part of the contract. So what?
this is my understanding, and I could be wrong. In these proceedings, the permit to work procedures, focusing specifically on clause 5.1 of the permit to work procedure, it was used to suggest that the applicant in the day in question, Mr. Madrad Singh, who I represent, had some supervisory role to perform. Because that is in effect what 5.1 says.
Yes.
That's in effect what 5.1 says,
I agree.
right? Good. Our issue with that is that there was a contract between the parties for the execution of the works. And in that contract, LMCS had an obligation to provide full-time supervision. I have not seen an express provision in the contract which incorporated the permit to work procedure. What I have seen is separate provisions which says that the contractor, LMCS, is supposed to abide by the permit to work procedure. I believe it's specifically stated at clause 8, which is something I would get to.
Yeah, it's certainly in there. I agree. I mean,
Right.
Precisely where I'm not concerned.
Right, good.
But
There is confusion. You are
are
asking.
you saying your client is confused?
No.
Is that your submission, that he
no.
was confused about his role?
No, I am not saying that my client was confused about his role.
Right.
What I am saying is that there's confusion with respect to how the permit to work procedure is treated in the face of a contract.
You're pushing at an open door.
Okay,
I agree with that entirely.
Okay, right.
I simply don't get the point you're making about it not being included in contract. So what difference does it make on the basis, without having to decide whether it is or is
Right.
not a part of the
Right.
contract?
The difference is-
we understand that in order to get to do the work,
Yes.
you have to follow the procedure
Yes.
and get a permit.
Yes,
Both of those things apparently were done.
yes.
The extent to which people understood precisely what it was and what it means is an issue in
Yes.
this matter,
Yes.
and one which we are obviously engaged in considering.
Yes.
So, to that extent, you're pushing an open door. I agree with you.
Yes.
But I don't understand the point about it not being. I
Okay,
don't.
so the difference it makes, Mr. Chairman,
Yes.
respectfully, is this. If the Commission accepts that the permit to work procedure was not incorporated into the contract, then there would be no basis, Mr. Chairman, for an advancement to be made that Paria was obligated to supervise the execution of the works.
I want to get this down right. No basis for an advancement to be made that Paria
Had an obligation to
Had
supervise the execution of the
obligation
works.
to supervise the works. So if we are to conclude that your point then is that if we are to conclude that the work permit system, incorporating the procedure and the permit itself, all right, that work permit system is not part of the contract, there is no basis for an advancement to be made that Paria had an obligation to supervise the works. That's your point, is it?
Yes.
Right, okay.
Yes. Now, I know our back and forth may have covered some of the rhetorical questions that I had posed in my document, but I would still...
I'm sorry if I've knocked you off your stride.
Yeah,
feel free to proceed on the basis that you were planning to proceed.
Good. Now, on what basis is the permit to work procedure being used as the document which contains the standard of conduct required to be achieved by the participants and not the contract? On what basis will you not find that the permit to work procedure was displaced by the contract as regards Paria? These are some questions that I posed. Now, under Clause 8 of the contract between LMCS and Paria, it states, contractors and contracted personnel are required to follow the permit to work procedure and standard work instructions at all times. Contractors shall ensure that all relevant employees receive the permit to work training.
That's paragraph which?
Okay, this could be found in the scope of works which outline the contract between LMCS and Paria, and I'm reading specifically clause 8.0.
8.0.
Yeah, 8.0. Right, and if the chairman permits me, I would give the actual page number. A moment, please, Mr. Chairman. I'm looking at page 579 of the witness statement bundle. The contract again was attached to the statement of Mr. Kazem Ali Sr.
Okay, yes, it's in another place.
Yes, and it's also in the, yes. Now, clause 9, may I proceed, please?
Yes, please do.
Right.
Yeah.
Clause 9 is one of several clauses in the contract which provides for contractor supervision. It reads, the contractor shall provide competent supervision at all times during the execution of the job. Contractor supervision must ensure that all employees on the job are aware of the hazards related to the job and the relevant control measures. As to the contract, Mr. Chairman, it is plain that LMCS was obligated to provide full-time supervision. It is our submission that that makes commercial and common sense, as they were the experts. We ask the Commission to note that both Paria and LMCS knew at all times the works would be subsea and that Paria were not experts in that particular type of work. Now, upon a perfunctory comparison of the permit to work procedure and the contract, there is overlap as to supervision. And as we established earlier, this has led to much confusion in these proceedings. We submit it makes no commercial sense to have two sets of supervisors with the same sphere of oversight for one set of work, especially specialist works as was the case here. This would lead to inefficiency and confusion in the event of a disagreement as to how the works were to be performed, and makes no commercial sense. I want to pause here for, okay, I
think that's a point well made. What I am concerned to know is whether or not you take the view that there might have been oversight at an earlier stage when the initial scope of works and the the tender was being made, so as to include an independent assessor of the work that was to be done, the emergency response plan, the various other documents that were necessary in order to win the contract, whether an independent person might have been employed to have tested that.
I totally agree.
Right.
I totally agree, because
whilst I accept, that it might not be necessary for that person to then, I mean, it would depend on each individual firm, I suppose, but it might not be necessary for that person to then carry out the supervision of the job work itself.
Correct.
That it may not be necessary if that expert, for want of a better expression, had considered all the papers as advanced by LMCS and agreed that they accurately represented, both in terms of the work to be done and the order in which it should be done,
yes,
the work that needed to be undertaken. And if that had been done, then perhaps we wouldn't have been in the situation that we're in.
Okay, this is a point that you, Mr. Chairman, made during these proceedings, and I totally agree.
Right. So you wouldn't be opposed, representing your clients as you do, to the idea that whatever level of supervision any Kenson employee might have been expected to have applied, be it intermittent every 4 hours or whatever it was, whatever level of, or oversight, call it what you will, whatever that was, all of that would have been made much simpler had there been some independent review of the application in the first place.
Yes, and as we are on the point of standard supervision, I'd just like to make one point which I don't have included here. Even if this commission is to take the view that Paria, under the permit to work procedure, had some supervisory role to play as regards the works that were going on at Bert 6, it is clear from the evidence that that standard of supervision was lower than that which LMCS was to perform.
Yes.
And, yeah, right, and that was driven home for me from the cross-examination of Mr. Randolph Archibald, when he said that Mr. Madrad Singh was only obligated to supervise what it is he could see, or as much as he can see.
Yes, I think that that's a matter for consideration by us. Also, the suggestion that perhaps every 4 hours was sufficient, all of those sorts of things we will obviously be reviewing. But you're pushing again at an open door.
Yes.
That LMCS clearly had an obligation to review the work continuously.
Yes, yes.
And whatever level of monitoring, oversight, supervision might be laid at the door of Paria, the fact remains that it was going to be, on the face of it, would be your case, less than LMCS.
Yes, Mr. Chair.
Right, I understand that.
Yes. Now, we submit, I believe I made that point before. Yes. Now, I do here have, Mr. Chairman, some questions that I pose, which I would want to read into the record. It may be that expert evidence as to the industry practice would have assisted the Commission if it was intended to suggest or inquire into the possibility that the permit to work procedure placed a full-time supervisory role on Paria, but no such evidence was led by this inquiry. What is the practice in the industry? The risk is always on the specialist contractor, as we say should be obvious and make sense. Or is that risk shared? Do the prices under the contract vary according to the allocation of that risk? Was the cost here commensurate with the risk being shared? Does the fact that the works were subsea and could not be seen properly by Paria not negate any obligation to supervise? That is a fact that was known by all. The ability to see exactly what was going on in the chamber, subsea.
Well, it was a camera.
Yes, and even with that camera, there wasn't a full view as the evidence has came out. The permit to work procedure, this is our respectful submission, and ultimately we know it's for the Commission to decide. The permit to work procedure cannot have placed a contractual obligation on Paria, because that is not what the contract says. If the permit to work procedure was binding, notwithstanding the existence of a contract, then evidence to that effect was required. In the absence of evidence of that nature, we respectfully suggest that you ought not to find that the permit to work procedure was more than a guideline. Now, I know earlier we had a back and forth over this permit to work procedure.
No, I'm not going to do that again.
Yes.
I mean,
Yes,
I have serious reservations about that submission.
Yeah, right,
yeah.
good. Yeah, but
that is your submission.
Yes. Right now, in terms of recommendations, and I want to be careful with respect to how I craft this. Ultimately, one of the things I see the Commission would have to make a recommendation on is how to improve the execution of works of this nature. And this would have to be done in the absence of evidence as to how works of this nature are ordinarily contracted for and performed. That's just something I put out for consideration.
Say that again.
In terms of recommendations, as I see it, one of the recommendations that the Commission would have to make is how to improve the execution of works of this nature. On any view, whether we like it or not, there was a problem with the way it was done. And what I'm saying, Mr. Chairman, is that the Commission would have to make this recommendation in the absence of evidence as to how works of this nature are ordinarily contracted for and performed.
Well, there are international standards we can look to.
Okay, well, yes, I agree with that. But I
don't need evidence for that. I mean, I've got it.
Okay, good. Yes, but so I'm just putting it out there to be something for this Commission's consideration. Now, before I close, on behalf of my clients, I would just like to express gratitude again to the Commission for accommodating us and giving us the opportunity to participate in these proceedings. And unless I can assist you further, these are the respectful submissions I wish to make on behalf of my clients.
Not at all. Thank you very much indeed for your submissions. I appreciate them.
Much obliged.
Thank you. Right. Well, that takes us, for a change, to a very early end to the day. I think we're entitled to a few of these on the basis we've had some very, very late days. So we will adjourn now. And I'm sorry.
I was looking at my watch to see if it was defective.
So we will adjourn now, and then we will hear tomorrow from the, first of all, from Counsel for LMCS, and then we'll hear from Counsel from Paria. Have you made up your mind yet as to who's going to be doing it, or are you going to do a tandem act?
Or we will do what, sir?
A tandem act.
Are we allowed to? If we did, to make life easier for both myself and Mr. Mutu,
I'm not going to stop you. If you think that we would be greater assisted by one of you concentrating on one aspect of the evidence and somebody else on some other aspect, and that would allow you to be able to address us in a more efficient way, then I'm not going to stop you from doing that.
But whichever mode we adopt, we give the undertaking, we will stay within, given the suggested time frames.
Well, that's really principally what I'm concerned with, that we, A, hear your submissions in the best possible light, and B, that it's constrained within the 2 hours that you have allotted.
Thank you, sir.
All right. All right, well, thank you very much indeed. See everybody tomorrow morning at 10 o'clock, I think I said. Yes, 10 o'clock.
All right.